Hey everybody, welcome to another Lexplainer brought to you by Nomad Law. I'm Chris. In this video I want to talk about something pretty basic, but I find it's a pretty common point of confusion among a lot of people, so I wanted to talk about it. And that's the difference between different types of intellectual property, IP. So in the United States, you kind of got your big four. That's patents, copyright, trademarks, and trade secrets. There's some other varieties of IP out there. You got your plant patents, your design patents, plant variety protections, domain names, arguably a separate type of IP, something called mask works. But I want to talk about those big four because I think those are the terms that most people are going to be familiar with. And they're also terms that I find people tend to use sort of interchangeably, particularly trademarks and copyright. I think get mixed up a lot, even in the media, which you would think ought to know better. But every so often I'll read an article about some recent trademark dispute, and in the headline there will be something about copyright, when in fact those concepts really have very little to do with one another. So how do you keep all this IP jargon straight? I don't have a handy mnemonic for you, but I think it's not that complicated if you bear in mind a couple of fundamental points. Number one, what exactly is it that we're trying to protect? Number two, where does this protection come from? Why do we have it? Number three, how do you get it? And number four, once you've got it, what does it do for you? And depending on what type of intellectual property you're talking about, those questions will come out totally different. Talk about patents first. Patents are about inventions. It might be a physical invention, like some kind of a machine or an apparatus, or it might be something a little bit more intangible, like a method or a process. Patents in the United States come from an act of Congress, the Patent Act. In American history, there's been a variety of patent acts over the years. It's been revised and changed a bunch of times. But the basic purpose has always remained pretty consistent, and that's to incentivize innovation, to encourage people to make discoveries and advancements in technology, and to share those discoveries to benefit society at large. And the incentive that's given is a monopoly over that invention for a limited period of time. And the way this works is that you file an application to the United States Patent and Trademark Office. That's a division of the federal government. And in that application, you have to disclose your invention. So you have to tell everybody what it is such that they could repeat it. And the Patent and Trademark Office looks at that application, and if they agree, yes, this tells us something new, something that wasn't known before, then they grant a patent. And that gives you a monopoly over the invention, essentially the exclusive right to make, use, or sell the invention for a limited period of time, currently 20 years, and you can use the patent to enforce those rights. Okay, so that's patents. Next, let's talk about copyright. And I do think it is helpful not to think of it as copyrights, plural, but to think of it more as just an abstract, uncountable noun, copyright. And that's because unlike patents and trademarks, there's not really a freestanding, discrete piece of property called a copyright. Instead, what you've got are works that are subject to this form of protection called copyright. Now, copyright, like patents, is about providing incentives. It's not about incentivizing innovation or discovery. Instead, it's about incentivizing the creation of works. What are works? Well, in the Copyright Act, they're described as works of creative expression fixed in a tangible medium, which is kind of a convoluted way of describing something that I think is pretty intuitive. It's what today I think we would mostly refer to as content. The classic example is a book. In fact, for most of copyright's history, since the Printers Union in England came up with the concept of copyright, it's been mostly about books. That's been the main thing that copyright is applied to. But today, in the modern era, Copyright applies to just about any type of audio-visual content that you can think of. Movies, music, pictures, software code, right? All of that is subject to copyright. Anything that can be recorded or written down just in just about any medium whatsoever is subject to copyright. So how do you get a copyright? Well, unlike patent, it's not a thing that you apply for or a stamped piece of paper from a government office. Copyright arises by creating a work. You can register your copyright with the Copyright Office that's run under the Library of Congress, and that has some important advantages. In particular, you can't enforce your copyright. You can't sue anybody for copyright infringement until you have a copyright registration. But most of the works that everybody is creating on a daily basis, the vast majority of those are never registered. But there's still a valid copyright subsisting in them. And what does that do for you? If you're the author of a work and you have the copyright? Well, essentially, you have the exclusive right to make copies of the work. The Copyright Act is a little bit more detailed than that, but that's the gist of it. It's the right to make copies, a copyright. And copyright lasts for the entire life of the author, plus another 70 years. Or it's just 95 years if it's a work made for hire, which generally means that it's a work that was created by a business through its employees. Again, a little bit more complicated than that, but that's the general idea. 70 years, life plus 70 years or 95 years. What about trademarks? Trademarks, in my mind, are totally different from patents and copyright. And that's because trademarks are not about incentivizing something, incentivizing innovation or creating new works. And that's because trademarks, at their core, are about consumer protection. They're about keeping the marks that are used in commerce distinctive so that consumers know what it is they're buying. Now what do I mean when I say a mark? A mark is basically a brand, right? In fact, I assume the words come from the same place, just like a cowboy might mark their cows with a cattle brand, and a merchant might brand their crate of goods with a mark to let everybody know where it comes from. Mark, brand, in my mind, they're basically synonymous. And mark is usually consists of words or pictures or some combination of the two. Although you might have more unconventional marks like, even a sound might serve as a trademark or a particular color. But whatever it is, it's something that's used on particular goods or services to let consumers know where those goods or services come from. And you get a trademark by using it. So just like copyright, there's no process called trademarking. And if you've got a trademark, what does it do for you? Well, unlike patents or copyright, a trademark doesn't really give you a total monopoly over the mark in the abstract. But what you do get is the right to prevent other businesses from selling related goods and services using similar marks, such that consumers might be confused about where the goods and services come from. So it's a little bit more limited in scope. But a trademark lasts for as long as you're using the mark. There's no expiration on it like copyright or patents. Finally, we've got trade secrets. And that term might be a little bit less familiar than the other three, but it's a very common type of intellectual property. Trade secrets protect information, data. It might be technical data like, lab results or a secret formula, or it might be business data like a customer list. Either way, you get a trade secret by keeping the information secret and by having security measures in place to maintain the confidentiality of the information, and by making sure anybody who has access to the information is under a contractual duty to also keep it secret. Usually that's the purpose of a non-disclosure agreement. Usually what these trade secret laws do, broadly, is if you've got a trade secret, gives you a claim against somebody who either acquires the trade secret or discloses the trade secret, but only if they do so through improper means. So if they learn your secret lawfully, there might not be anything you can do about it. So those are the 4 major categories of intellectual property. Well, hopefully that helps to clear things up a little bit. For more information, check out our website and our blog, or hit us up on Twitter, Facebook, Quora, or what have you. Thanks for tuning in.